Hey guys, it's Mahoney coming to you on Tuesday night with another Tuesday night tip. So last time I said that I would talk about a unilateral mistake versus a mutual mistake in a contract and the difference between the two. So this is a really complicated area of the law and an area that you definitely want to talk to an attorney if you ever get involved in. But a mutual mistake just means both parties make a mistake when they're entering into the contract. And most of the time, the court's going to make a distinction between a mutual mistake of fact and a mutual mistake of law. So a mutual mistake of fact would be that we enter into a contract to buy a house at 920 Stover Street here in Freeport, and we mistakenly think that the house that we're looking at, both of us, when we go to sign the contract to buy is 920 Stover Street when in fact it's 915 Stover Street. So we were looking at the wrong house. So we both made the same mistake. Well, that's a mutual mistake of fact, meaning it's the wrong house. And generally, the court is going to allow the parties to walk away from a contract like that when there's a mutual mistake, both parties, and it's of a fact. Now, it's got to be an essential fact. Okay, one of the things to remember is courts always want to try to enforce contracts. They're going to do everything they can to uphold a contract. So let's say we made a mistake and said that the closing was going to be on or before February 29th, and because we thought it was a leap year. I think that's right. And it's not a leap year. We were wrong about that. Now, is that an essential element of the contract? No, the closing date can be any time. So the fact that we made a mutual mistake in that situation isn't going to mean that everybody gets to get out of the contract. It's got to be a mutual mistake, and it's got to be a mutual mistake of something significant in the contract, what they call an essential term of the contract. Now, mistake of fact versus mistake of law. Now, that's a different situation, and generally the courts are not going to allow you to get out of a contract even if you make a mistake of law. Believe it or not, now if the contract is against the law, that's different. But if you make a mutual mistake of law, a lot of times courts are going to enforce the contract. The theory came out of the original theory regarding criminal cases, that just because you didn't know the law doesn't mean that you get out of a contract. Now, courts have kind of gotten away from that a little bit and have decided, that maybe that's not the best thing, but courts are kind of all over the place on that. But if you notice, a lot of the contracts that you enter into, there'll be a section that says, if part of this contract violates the law, then the rest of the contract is valid. I mean, that's part of the reason that is there, is to make sure that if anything becomes illegal, that the contract still happens. But again, it's got to be a mutual part of the contract. If it's not an essential part of the contract, then the courts are going to enforce it. Now, a lot different than a unilateral mistake of contract. A unilateral mistake means that one party's making a mistake and the other party is not. Well, most of the time, the court is going to enforce that contract, and there's a lot of different ways that this could happen. So let's say that one person is making a mistake and the other person has no way to know that they're making a mistake. Well, in that case, then the court's probably going to enforce the contract. I actually had this situation with a personal injury settlement. I settled a personal injury case. This was a long time ago for about $80,000. And I actually had the check in my hand. And then I found out later that the insurance policy in that case was only $25,000. And the adjuster didn't have authority to settle the case for $80,000. Well, I had no way to know that. I didn't know what the policy limit was. I hadn't filed the lawsuit yet. I never asked. And so I said, well, I have an enforceable contract. Well, the insurance company canceled the payment on the check. Turns out I had to do a whole bunch of stuff, and it took a period of time, but they did in fact end up owing the money on that particular contract, and they did end up paying it, but it took a little while. But that was a mistake on their part, and there was no way for me to know. There's a lot of other cases where if I had a way to know, maybe they'll be allowed out of the contract, or they can try to argue that what we call an equity response, which means I got unjustly enriched or something like that. And this gets complicated when you're talking about business negotiations. I mean, if a person makes a mistake and does a calculation wrong and offers me an amount of money that they shouldn't offer, and I take it, and I can spot that they're doing a calculation wrong, but I go, hey, if you're dumb enough to make me the offer, then that's on you. Well, that's kind of an arm's length business transaction. As long as I'm not holding anything from them, I'm not hiding anything, I'm not committing fraud, the court's going to look at them and go, well, you had a chance. The fact that you made a mistake in that situation, even though it's an essential element, that's business. That's how business goes. You did your math wrong. You did your math wrong. You've seen that with bids where people submitted a bid for a project. A contractor submits a bid for a project and turns out they did their math wrong and they ended up bidding way less than they needed to in order to make money on the project. And then they still got held to the terms of the bid. They made the bid. They had a chance to do all the calculations. Even though it's their mistake, then they're going to get held to that contract. So complicated area, things to remember. If both parties make a mistake and it's to an essential element, we thought we were buying house A when really we were buying house B, court's going to let you out of that contract. If it's a mistake of law, the courts aren't necessarily going to let you out of that contract, but if it's against the law, the courts are going to let you out of that contract. If the mutual mistake is not to an essential element, then the courts will reform the contract. They'll put in what is normal in the course of business. So like if the contract doesn't have a duration, but duration isn't a big deal. Like if you enter into a lease and it doesn't say how long it is, then the court's going to say, well, it's a month-to-month lease. We know that that's kind of the minimum that anybody does. So if it doesn't say duration, well, now it's a month-to-month. Courts will do whatever they can to enforce. Let's say you did a contract to purchase a piece of property and it doesn't have a closing date, which a contract is supposed to have. Well, then the court will just say, well, it's got to be a reasonable closing date. You got to close by X date. Now, let's say that the contract is not in writing. All right, well, now that doesn't work because you have this thing called the statute of frauds that says certain contracts have to be in writing, and the contract for the sale of real estate is one of those that has to be in writing. So the court can't reform that one. But let's say the writing isn't the way it's supposed to be. It's emails back and forth, and the emails say that there's an agreement and all this type of stuff. Again, is that a sufficient writing for the courts to enforce? Well, maybe. It's not signed, but also in the normal course of business these days, a lot of times things are signed electronically. So that might be good enough. As long as the court can determine what are the essential elements that are needed for that particular contract, then it can enforce it. So big, complicated area. Contract lawyers are I'm not supposed to say the word specialty in the state of Illinois, but they're a specialty, something to focus on. So if you get in that type of situation, make sure you contact an attorney and understand that unilateral mistake issue. That's something that's really kind of up in the air. I thought I would add something to my Tuesday tips. When I went to law school, my focus was on constitutional law. I was big on the Constitution, big on criminal procedure, which is essentially constitutional law. So I thought I would do a constitutional tip in addition every Tuesday because it's something that I love and it's near and dear to my heart. And a lot of times, it's not something that we study as much as I think that we should. So first question on constitutional law. The Vice President of the United States. Does the Vice President have anything to do with regards to Congress? The answer is yes. The Vice President presides over the Senate. The Vice President is the head of the Senate. So then the second question is, well, does the Vice President vote? Only in the situation where there's a tie between the senators. Article 1, Section 3 of the United States Constitution indicates that the Vice President will preside over the Senate and only vote at a time when there is a tie amongst all the senators. So if there's a 50-50 tie, then the deciding vote is cast by the Vice President of the United States. And this does happen often. In fact, everybody thought it was going to happen recently with the vote on the Affordable Care Act until John McCain got on his airplane and flew back and looked at Mitch McConnell and did one of these and voted it down so that it wasn't a tie and it didn't go to the Vice President Pence, and the Affordable Care Act is still law. So it does happen periodically. Article 1, Section 3 of the Constitution. Hope everybody has a great Tuesday, and thanks for watching.